In this video, we are going to look at Australian federalism. Former Governor-General and High Court Justice Sir Ninian Stephen described federalism as the foundation upon which rests our whole Australian polity, our system of government. So what is federalism? Why was it chosen for Australia? And how does it function? At its core, federalism is a system of government in which sovereign legislative power is shared between two or more territorially defined levels of government: a central, national government, and a number of regional, state and or local governments, and where the distribution of power is effected by a written constitution and policed by an independent arbiter. As such, federalism is distinguishable from a unitary system of government in which all power is vested in one central government, and a confederation, which is generally used to refer to an association of member states that delegate specific, limited power to a federal body, but in which sovereignty remains with the individual member states and a separate sovereign federal state is not created. Can you think of countries with a unitary system of government and countries that operate within a confederation? Consistent with this definition of federalism, the Australian Constitution establishes Australia as a federation with the following characteristics: a central national government called the Commonwealth of Australia, state governments being the then existing colonies and any other states that may be admitted into the Commonwealth in accordance with the Constitution, a list of matters that the newly created Commonwealth of Australia may legislate upon. Some of these matters are expressed to be exclusive to the Commonwealth. Most matters on which the Commonwealth can legislate, however, are not expressed to be exclusive. As a result, they are matters on which the states also can legislate. These are called concurrent powers. Most of these powers are found in Section 51 of the Constitution, which lists 39 matters on which the Commonwealth can legislate. You should have a read of that section. Importantly, if a matter is not listed in the Constitution as within the Commonwealth's power, then the Commonwealth cannot legislate upon it directly. We will come back to the distribution of power between the Commonwealth and states shortly. The Constitution also provides rules that govern situations when both Commonwealth and state governments legislate upon the same matter. Principally Section 109 of the Constitution, that provides that when a state law is inconsistent with the law of the Commonwealth, the law of the Commonwealth shall prevail, and the law of the state shall, to the extent of the inconsistency, be invalid. And finally, the Constitution provides a judge to adjudicate upon disputes between the Commonwealth and states, and between state and state, namely the High Court of Australia. What's missing from this list? Local government. Local government is not a creation of the Australian Constitution. Local government is a creation of state law. As such, they can equally be disbanded and merged by state law. This is not the case with the states, however. Their constitutional recognition means states can only be disbanded or merged in accordance with the processes laid out in the Constitution. So why did the framers of our Constitution choose federalism for Australia? To answer this question, one must first understand a little about the circumstances of Australia's creation. There were many reasons why the then colonies chose to formally separate from the United Kingdom. These included a newly forged sense of national identity, the desire to facilitate a strong national economy, and defence. The colonists were prepared to cede to the new national government those powers necessary for it to perform these important national functions. At the same time, however, the soon-to-be states were concerned to protect their own power and influence from what they feared might become an overbearing national government. As a result, they were loath to cede to the new national government more power than what was thought necessary for it to discharge its new national functions. The solution they settled upon was federalism. Federalism provided a mechanism for both creating and empowering a new national government, while at the same time respecting and protecting the separate existence of the colonies, which would become states within the new nation. The division of legislative power between the Commonwealth and states, settled on by the framers of our Constitution, tells us a lot about how they saw the new federation operating. Have a look at this list of matters on which the Commonwealth has been empowered to legislate. Also have a look at the matters on which it is not empowered to legislate and that were left to the states on federation. you will see that, consistent with the forces driving the desire for nationhood, that the matters over which the Commonwealth was given power to legislate relate primarily to trade and commerce, the infrastructure necessary for trade and commerce, and defence. Does the list surprise you? Are there items in either column you thought would have been in the other column? You also might be asking yourself, but doesn't the Commonwealth pass laws on matters in the right-hand column? Don't we have a Commonwealth laws protecting the environment? If yes, how can it do so validly? We will come back to this question shortly. In the meantime, let's look first at federalism's other advantages, in addition to creating, empowering, respecting and protecting separate national and regional governments. First, federalism provides a stable mechanism for extending democracy across a large territory and population, one which gives citizens a say in how national issues are addressed at the national level and local issues are addressed at the local level. Federalism also divides and disperses power across a number of governments, thereby preventing a single government from being able to impose its will on all the people. As Justice Kirby noted in the Work Choices case, it is a feature that tends to protect liberty and to restrain the over-concentration of power, which modern governments, global forces, technology, and now the modern corporation tend to encourage. Federalism also strengthens government responsiveness to local interests. Federalism decentralises local issues to state governments which are closer to the people and better able to reflect their preferences in their policy and service delivery decisions. Moreover, federalism provides citizens with choice and diversity. Federalism allows people and businesses to compare the policies and performances of states and to move to those states that best meet their preferences. This results in states competing with each other to attract workers and investment. This political competition disciplines governments to be efficient, effective and responsive in the delivery of public goods and services in the same way that price competition disciplines private suppliers of goods and services. Next, federalism creates opportunities for experimentation and interjurisdictional learning. US Supreme Court Justice Louis Brandeis famously referred to federal systems as laboratories of democracy, in which a state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country. A good example of this principle in action was the reformist South Australian government of Don Dunstan in the 1970s. Mr. Dunstan's government introduced many reforms that today we take for granted. These included consumer protection legislation, anti-race and sex discrimination legislation, and the decriminalisation of homosexuality. Further, by retaining state governments with significant functions, federalism provides for more efficient government. Commonwealth and state governments are constantly compared with each other. This places governments under political pressure to improve their performance through innovation or through learning from the successes and failures of other jurisdictions. The result is said to create a cycle of experimentation, observation, review and improvement, in which successful policy innovations are diffused across jurisdictions to the benefit of all citizens, and unsuccessful innovations are either avoided or improved upon by other states. Finally, federalism guards against the national government being overwhelmed by its responsibilities and contains the consequences of policy failure. As one commentator observed, a bad regulation in one state will generally be less costly than a uniformly bad regulation everywhere. As can be seen, federalism has a number of advantages. However, federalism also has a number of disadvantages or problems. For some, the problems are structural, that Australia is overgoverned, that for a country with our population and population density around major cities, there are just too many governments and too many politicians. And yet for others, the problems lie in Australian federalism's outdated division of roles and responsibilities between Commonwealth and state governments, that they are governed by a 19th century constitutional division of powers that is not capable of meeting the challenges presented by increasing globalisation, international economic competition, and rapid advances in technology and communication. For others, the problem lies in federalism's blurred roles and responsibility, that the Constitution simultaneously allows both Commonwealth and state governments to legislate on the same topic, reflected in that long list of concurrent powers listed in Section 51. This problem frequently is compounded by the failure of Commonwealth and state governments to cooperate and work together effectively to address issues that fall within their concurrent powers. One only has to look at recent debates over education and health reform, the distribution of GST revenue, and climate change policy to see that our federation frequently is characterised by disagreement, blame shifting, and a lack of accountability. Others point to multiple states regulating the same issues, leading to duplication, overlap, and inconsistent regulation that imposes unnecessary costs on businesses operating in more than one state. For example, each state has its own workplace health and safety regulation that can differ in their detailed requirements. Such are the problems with Australian federalism that recent research revealed that 90% of citizens had a negative view of the present federal system, and 75% would prefer a different system to that which exists today. This is matched in political, academic, and business circles where there is a growing consensus on the need to reform our federal system of government. So how did we get to this situation? How is it that a system with so many theoretical and practical advantages is subject to so much criticism? Different people have different answers to the question. Here are mine. First, the framers of our Constitution did not establish mechanisms or institutions for the effective and efficient exercise of concurrent and overlapping powers by Commonwealth and state governments. The main coordinating mechanism today is the Council of Australian Governments, or COAG, and the various ministerial councils under it. However, you will find no mention of COAG in the Constitution. It is the creation of the Commonwealth, and it relies for its effectiveness on the cooperation and goodwill of its members, which is not always forthcoming, especially if the issue is politically contentious. This brings us to my second reason, politics. If the parties in power at the Commonwealth and state levels are not ideologically aligned, reaching consensus can be difficult. And even if they are ideologically aligned, consensus can still be difficult to reach because Commonwealth and state governments have different priorities. The Commonwealth government is elected to govern in the national interest. State governments are elected to govern in the interests of their state. A state government's perception of its state's interests may not always align with the Commonwealth government's perception of the national interest. The debate over the management of the Murray-Darling Basin that spans parts of Victoria, New South Wales, South Australia, Queensland, and the ACT is a good example of this. Another reason is that the High Court has interpreted the Constitution in a manner supportive of an expanded Commonwealth role. You will study in constitutional law that the High Court has applied a broad interpretation to Commonwealth powers, such as the external affairs and corporations powers. This is how the Commonwealth can pass environmental protection laws, for example. As we observed earlier, the Constitution does not confer on the Commonwealth the power to legislate for the environment. However, the High Court has held that the Commonwealth's power to legislate with respect to external affairs empowers the Commonwealth to legislate on any matters as subject of an international treaty to which it is a signatory. International environmental treaties, thus, have given the Commonwealth the power to legislate on environmental matters. And finally, there is what is called the vertical fiscal imbalance. This refers to the fact that most tax revenue in Australia is raised by the Commonwealth Government, and that the states do not raise enough revenue of their own to provide the basic services their citizens expect from them, such as hospitals and schools. This makes the states dependent on the Commonwealth for money to properly discharge their responsibilities in those areas. And the High Court has held it is permissible for the Commonwealth to provide that money to states on the condition they spend it in accordance with the Commonwealth's directions. These are called tied grants. These latter two factors in particular, the High Court's expansive interpretation of Commonwealth powers and the vertical fiscal imbalance, have placed the Commonwealth in a constitutionally and fiscally dominant position vis-à-vis the states, which position successive Commonwealth governments have leveraged to place themselves at the centre of policy development on a range of issues traditionally thought of as state responsibilities. Sometimes the Commonwealth has done this by directly legislating for an issue against the wishes of the state or states. For example, by preventing the damming of the Franklin and Gordon rivers in Tasmania in the 1980s, and more recently by legislating the definition of marriage. In the main, however, the Commonwealth has leveraged the states' dependence on it for the revenue they need to discharge their core responsibilities to make the provision of financial grants to the states conditional on the states implementing the Commonwealth's policy preferences in key areas in respect of which it has no clear constitutional head of power. These include education, health, and urban planning, to name but a few. In conclusion, federalism has a number of advantages and disadvantages. The advantages mean the system should not be abandoned. The disadvantages mean there is scope for improvement. What changes to our federal system would you make? I hope you have found this topic interesting. Your lecturers look forward to discussing the concepts covered in this video with you in lectures.